Rules Committee come to order, and thank you very much for joining us for another beautiful and fun day at the Rules Committee. Today we will be considering HRES 1917, the Blocking Regulatory Interference from Closing Kilns Act of 2017, and HR 1119, the Satisfying Energy Needs and Saving the Environment Act. HR 1917 would expand the compliance dates of the final Environmental Protection Agency 2015 BRIC-MACT rule pending judicial review. Legal challenges on the final rule are currently pending in the Court of Appeals for the District of Columbia. I think it would be a bad governance issue to implement a rule that would likely cost up to $100 million annually before the courts have an opportunity to rule on the legality of this rule. This legislation will directly benefit the 7,000 workers employed by the brick industry nationwide. The second bill under consideration addresses refuge-to-energy plants, which have removed an estimated 214 million tons of coal refuge from the environment at no expense to taxpayers. H.R. 1119 will ensure environmentally beneficial coal refuge to energy facilities put at risk by the EPA's Mercury and Air Toxic Standards Rule can continue to operate and perform significant cleanup activities in Pennsylvania, which I believe has a preponderance of these plants, and certainly other regions of the coal country. So without objection, I'd like to welcome the gentleman who was in my class, the class of 1996, the gentleman who also graduated from West Point and is our dear colleague John Shimkus, as well as the gentleman from New York, Congressman Tonko. You didn't know he'd been around that long, did you? He looks so young, it's just amazing. But we came in together, absolutely. We welcome them to our first panel, and before we get to you, Chairman Shimkus, we're going to go to the ranking member, but without objection, anything either of you have in writing, they will be entered into the record so that we complete our testimony properly. We have our awesome stenographer who's with us tonight, and she knows that it helps her complete the record properly. So thank you very much. Before we move to our first panel, I'd like to recognize the gentleman, the ranking member of the committee, the gentleman from Massachusetts.
Well, thank you, and I'll be very brief. I just want to welcome our two witnesses, and I'll just say in advance that I want to associate myself with the remarks of Mr. Tonko. And with that, I'll yield back. He's a nice guy.
Despite what we accused him of, he's a nice guy. Well, let me say this, Chairman Shimkus, your leadership over the years on so many of these environmental issues, substantive issues to protect American jobs, but to make sure that we find a way to make them work for not only a better environment, but also jobs, is one of the keys, I think, to your leadership demand and ability for a conference out of energy and commerce. We're delighted that you're here. The gentleman is recognized.
Thank you, Mr. Chairman, and thank you, Mr. McGovern, for those very kind words. I'm pleased to be here today to discuss two bills that promote small business and benefit consumers. Throughout this Congress, the Energy and Commerce Committee has sought to make our nation's environmental regulations smarter, and that is exactly what these two bills do. H.R. 1119, the Sense Act, helps facilities that take coal refuse and turn it into electricity and ash. And let me kind of explain what a coal refuse pile is. It's in coal country, we call those gob hills. They are areas that have been mined, but for a lot of people, the little bit of coal that's in there and the other stuff is too difficult to use in electricity generation. So they just pile up. We call them slag hills too. This takes those and puts those back into the electricity generation cycle but it's a little bit of different technique than conventional electricity generation. That's the importance to know. And then you are able to, these unsightly piles of coal refuge then can be reclaimed and in essence reused. This bill protects coal refuse to energy plants by simply allowing for an alternative compliance method under the Mercury Air Toxic or MATS rule. This bill is good for the economy and good for the environment. H.R. 1917, the BRIC Act, extends regulatory deadlines for brick and clay product manufacturers until judicial review of the EPA's rules are completed. and I'll just talk this through real quick. The last cycle, EPA administered the rules. These manufacturers went to the courts. Of course, going through the courts take a long time. And by the time the courts ruled in their favor, either they had excessive additional costs that they had placed on that didn't really need to because the court said that the EPA was outside the rule of law, or they just closed down. This ensures manufacturers are not required to spend millions of dollars complying with the rule that may subsequently be vacated by the courts. An unfortunate scenario that already has occurred once in 2003 after many companies had taken the expensive steps needed to comply with the rule. Similarly, H.R. 1917 also extends by 3 years the deadlines for the second phase of the New Source Performance Standards, NSPS, for new residential wood heaters. This extension will allow the necessary time for manufacturers to design compliant product models. As of today, new wood heaters are already complying with the first phase of this rule, which has resulted in a 90% emission reduction. So you have heaters that use wood as a fuel. There was a standard placed. The industry moved to do that. There's a second standard that maybe the big producers can get there. The smaller ones, they can't reach that goal right now. So then the question is, how clean is clean, and what is the cost of compliance, and do you price yourself out of using wood heating? And that's the simple background. Manufacturers are simply asking for more time to engineer technology that achieves the more burdensome and costly emission reductions required under the second phase of the rule. Mr. Chairman, both of these bills provide the necessary time and flexibility to small businesses and industries so that they can meet the requirements of the Clean Air Act without experiencing needless, impractical regulatory burdens. For this reason, it is imperative that we move these bills to the floor so we can help the many small businesses throughout the country, as well as their workers and customers that are being threatened by unreasonable regulations. And with that, I'll yield back my time.
Mr. Chairman, thank you very much. Mr. Tonko, welcome. We're delighted that you're here, and it's good to see you again, Paul.
Thank you. Thank you, Mr.
Gentleman's
Chair.
recognized.
To Chairman Sessions and members of the Rules Committee, thank you for allowing me to testify this evening on the rule for H.R. 1917, the Blocking Regulatory Interference from Closing Kilns Act of 2017, or referred to as BRIC, which now includes H.R. 453, the Relief from New Source Performance Standards Act of 2017, as a new Section 3. I'm also here to testify on the rule for H.R. 1119, the Satisfying Energy Needs and Saving the Environment Act, or the SENSE Act. These bills were reported out of the Energy and Commerce Committee in December of last year. I'm in strong opposition, Mr. Chair, and members of the committee, to these bills. They grant unnecessary favors to special interests, and those favors come at the expense of people's health and people's welfare. Everyone claims they are for clean air, and yet we see a steady stream of legislation to undermine the regulations that provide it. The Clean Air Act was designed to improve the emissions performance of industry so that we would have prosperity without pollution. Postponing or undermining rules that seek to reduce hazardous air pollutants is not good for Americans. I would encourage all members to consider what is in the best interest of all our constituents. We also know that pollution can be a tremendous drag on our economy and productivity, causing respiratory illnesses, costly hospitalizations, missed school days and work days, and even premature deaths. I'm a strong supporter of manufacturing, but manufacturing does not have to come at the expense of the health of surrounding communities and our constituents. The decades of progress we have made in cleaning up the air have come with progress at the same time in our economy. That is the record of the Clean Air Act. Regarding the BRIC Act, I understand the combination of the change in the economic climate for the brick and clay industry, and the history of this rule is frustrating for the industry and to the authors of this legislation. But H.R. 1917 would delay the implementation of this rule until all legal challenges to the rule are resolved by the courts. It would also delay any subsequent rule issued that is similar in scope and objective until any legal challenges to it were completed as well, offering opportunities, great opportunities for endless lawsuits on this issue. H.R. 1917 establishes a very bad precedent of delaying public health protections until all legal actions have been resolved. We cannot agree to setting this precedent and establishing a process that will delay important public health protections and encourage frivolous legal challenges to clean air rules. In November, the courts noted that EPA is already close to 20 years overdue in issuing an effective MACT rule for these facilities, the Maximum Achievable Control Technology rule, that is. There is no justification for further delay. Section 3 of H.R. 1917 incorporates the text of H.R. 453. This bill delays new performance standards for wood heaters by an additional 3 years. The standards for these appliances have not been updated for nearly 30 years. New standards are already long overdue, and the lack of performance standards for outdoor wood-fueled boilers has hurt the market for those given appliances. They produce so much pollution that neighbors of these installing them have filed nuisance complaints against their use. Local communities have passed ordinances restricting or banning their use. That is not the situation we want. There are companies today that produce compliant products. I'll repeat that. There are companies today that produce compliant products. These innovative companies should be rewarded with the additional market share they anticipated when they made their investments. Instead, this bill allows the companies that drag their heels to continue to sell substandard products that use more wood to produce less heat and generate tons of extra pollution, causing health problems within local communities. Wood stoves and wood heaters are very long-lived products. A 3-year delay translates into decades of additional pollution. There is no reason for this. Finally, we have H.R. 1119, the Sense Act. This bill provides a carve-out from the mercury and air toxic standards, or MATS, rule for about a dozen utilities that burn waste coal as fuel. The detrimental health effects of mercury are well documented, and these plants can meet these standards. H.R. 1119 is an unnecessary bill. States already have the ability to provide some leeway for these plants if they so choose. But the fact is, the state would have to do that by asking other traditional coal-fired utilities to do more. Asking coal-fired utilities to do more. This bill is unfair to other utilities and the local communities that will continue to experience greater mercury and greater air toxic pollution. The courts would not grant special favors to the waste coal utilities, so they are now coming to Congress. This bill should be rejected. These bills provide so-called relief to industry by shifting the health and financial burdens of pollution onto the general public. I do not believe that is a fair trade-off. Usually, I would be asking for an open rule, but it is my understanding that no amendments have been filed, which I think reflects that amendments will not be enough to improve these bills sufficiently to gain the support of many members. Simply, these bills should be rejected. With all of the important issues facing our nation, it is puzzling why we are spending our time on this divisive legislation. We should be and could be creating jobs, improving public health, and cleaning up the environment by investing in modernizing, upgrading, and indeed replacing infrastructure. That is a far better approach for the public and for the economy than any of these bills that would undermine public health protection for the benefit of a few special interests. And with that, Mr. Chair and committee members, I thank you again for allowing me to testify here this evening. I yield back.
Mr. Tonko, thank you very much. Chairman Shimkus, I'm certainly not completely as well versed as Judge Hastings is on some of the aspects of our federal courts, but it's my understanding that where it relates to administrative law, original jurisdiction resides within the D.C. Court of Appeals. And original jurisdiction means it comes there without going to a prior district court, comes there. These are generally very careful, I'm not going to say better judges, but they're judges that really are used to the construct of administrative procedures. It's not like a criminal case. They handle these. And I think they do a pretty good job of getting through decision-making that the Supreme Court also many times finds that the work that they do very deliberative and on point. I think it's important that you have raised the point, before we start doing something, and this is not a new concept to you, I know, but let's find out what the courts say, because this is a conflicted matter. And let's see what the courts, how they would rule. Then let's go ahead and make sure we accept that answer. I don't think it's a long time to say go to a district court, wait till it gets scheduled, then go to the circuit court, and then go to Supreme Court under some docket that might take years. And so while I do believe that an argument that Mr. Tonko has made, I think because we are dealing with the D.C. court, original jurisdiction, and the court that makes these decisions does so with expertise of administrative procedures, and they rule so carefully on these. I can err on the side where you are. Let's get an answer before we go and disrupt the marketplace. Is that really your main point, sir?
Well, yes, I think that's pretty well summed up. Remember, even to take a case to the courts is costly. You got to go downtown, get lawyers who are expert in the courts here, and it takes years, so that costs pile up. And then, they add insult to injury, the time the clock runs, you are confident you're in the right, so confident that you're willing to put money into fighting the rule. You win, but it's taken so long that you've complied, and you've actually paid maybe 3 times more now for that because of just the litigation. Had you allowed the courts to make a decision, then the process would have been come back to us. What problem do we have a lot of times is we don't write our legislation clearly enough. We allow the bureaucrats to write the rules, and if the rules aren't in compliance with the intent of the law, it gets thrown out. So the intent is to don't force people to pay numerous times when they win in the courts.
And I think what I'm suggesting, and I think your wisdom would tell me this, John, and we trust the Court of Appeals to make a wise judgment. We didn't say, we don't know the answer, but we did say when that is done, and I believe it can be forthrightly done. And I'm not trying to engage in any political argument, but more a philosophic argument that I believe that the D.C. court weighs when its thumb gets on an issue, and those issues that we give them are regular in nature to their understanding of the substance. They're able to make a quick decision. Thank you very much. Mr. Woodall.
Thank you, Mr. Chairman. I thank our witnesses. These environmental bills that pass out of committee on a straight party line vote are the ones I like the least, because I know the members of the committee, and I know how committed folks are both to manufacturing and to the environment. And so if they show up here on straight party line votes, I feel like we've already lost our opportunity to influence the process. Bigger issues have been taken on. So I thank the gentleman for testifying, and I look forward to supporting the rule. Mr. Chairman, I yield back.
Thank you very much. Gentleman from Massachusetts.
I really have nothing to add. Like I said, my views are with Mr. Tonko on this, and it is what it is, and this will go to the floor, and so not much more to say. But thank you for being here.
Gentleman yields back his time. Thank you very much. The gentleman, Judge Hastings.
Thank you very much, Mr.
Yes, sir.
Chairman. Mr. Chairman, picking up where you properly explained how the court process works with reference to these matters, you are aware, I would imagine, as pertains to these measures, and maybe Mr. Shimkus can help us. Have any of the litigants asked the court to stay the brick and the structural clay rule?
Looking to my crack staff behind me, and the answer is no.
And with that in mind, when properly petitioned, the courts have the authority to issue stays. So in my view, at least, there is no need for another remedy since a fair and appropriate process already exists. Paul, what's your take on that?
Well, I think with the public policy that's being developed here, you would encourage frivolous lawsuits and delay progress. And again, the courts have that power to offer a stay, and I think we should allow it to rest there, not taking up the
Right.
matter in Congress and manipulating the
Well, I
process.
won't belabor it. I'll have an opportunity in managing the rule to discuss it further. But in many respects, and this is a total departure, I appreciate both of you, and you as well, Mr. Chairman. But it cannot go ignored that these are not critical matters that require any measure of urgency, notwithstanding all the views you may have with reference to them going forward. But let me bring it up, we should be dealing with DACA. This is the day that the deadline was set by the Trump administration to pass a bill to protect the Dreamers. And yet a bill to protect the Dreamers, as I understand the week's schedule, is not going to be taken up. And my recollection is that we've offered on motions to recommit and at least a number of other ways procedurally, 23 times we've offered to bring the Dreamer Act to the floor, and each time the majority has rejected it. And we left here last week, Mr. Chairman, and you know, these tragedies that continue to occur around the country touch us all at one point. You in Texas and up in New England with Mr. McGovern, and now Florida and the district that abuts mine. There was no place that I went, from either the bank, the cleaners, the grocery store, 2 town hall meetings, and a fundraiser, and there was not one time that I did not encounter people saying, what are you all going to do about these problems that we're having with the gun epidemic in our society? We've had since 2014 1,371 mass shootings. And I turned away from the Academy Awards last night to pick up on where the local news was in my area. 6 shootings that had taken place. And then we see the tragic situation of the young man killing his mother and father in Michigan. There are so many complexities, and for us not to be addressing them allows that people think we're incapable, and I don't believe that we are. So just to give you some added stats, there have been 11,000, almost 12,000 teens aged 12 to 17 killed since 2014. And 2,812 kids age 11 and under. And most of these are attributed to gun violence. Now, I keep hearing that the guns don't cause the problem. And at a town hall meeting where I was taken to task by a gentleman on the subject of teachers being armed, and the state of Florida is addressing a measure in its legislature, which is meeting in its final week, and the sooner they finish, the better. That's as crazy a crowd as I've ever seen calling themselves legislators. But all things are considered, Mr. Chairman, what I had the gentleman say to me at a town hall in a very nasty way is that, you know, there are 2,000 varieties of automatic weapons. And I said to him, then ban all 2,000 of them then, and we would not have some of the deaths that have occurred, at least by that kind of weapon, by anybody new having received them. So for us not to address those matters, and then to ignore the funding of the government, which is of critical import, and on the 23rd is when that deadline expires. And during that period of time, it'll be interesting to see how we play this, because the youngsters from around the country on the day of the 24th are going to be here en masse. And it's going to be interesting to see how we kick the can down the road again and don't deal with gun violence in our society, and obviously don't deal with the Dreamers. On another stat with the Dreamers, 120 of them lose their protected status every day that we don't act. And we can't continue down this road. Y'all got to do something in the majority to address some of these things that need to be addressed in this country. That's off the point with reference to you, gentlemen. I'll see you on the floor on Wednesday. All right.
Judge, thank you.
Thank
very
you.
much. The gentleman yields back his time. Louise, we're here talking, we have Paul Tonko and John Shimkus. We're talking about two bills that we have previously handled before, but bringing them back.
I recognize the familiarity.
And so we're talking about how good John Shimkus looks.
We always did.
Well, we still do
Have
then.
you done something different, John?
No, I admitted that he and I came up together, and somebody said he looked a whole lot better than I did, and I agreed with that, so
Gave up easy, did you?
I gave up easy. Does the gentlewoman seek any
I
time?
do not.
Thank you very much. The gentleman from Freedom, Colorado. Gentleman does not seek time. The gentlewoman from Wyoming does not seek time. Thank you very much. Gentlemen, thank you very much. I think there are lots of things that we learn every single time we have expert witnesses such as you who not only come to the Rules Committee, but Mr. Tonko, we want to make sure you're given the time to properly explain yourself, to forthrightly offer some, not admonition, just admonition about your ideas, but to tell us where you stand. And we think every single member of Congress, when they come to the Rules Committee, deserves a right, and they get one to come and speak forthrightly. And we appreciate not only your confidence in that, but you taking advantage of it, and we want to thank you. I'd like to yes, sir.
Mr. Chairman, I thank you and Ranking Member Slaughter and the members of the committee for the opportunity. And
Thank you very much. We do care about this being a process that you can walk out and say, well, at least, I had a chance to say my piece. I would like to ask if both of you please make sure anything you brought in writing be available to our awesome stenographer, and that it will complete her action for the day. And thank you very much.
yeah.
Thank you, Mr.
Thank you.
Chairman.
Is there any other member that would seek to wish to give testimony to H.R. 1917 or H.R. 1119? Seeing none, this now closes the hearing portion of the committee hearing today. And we have any more business before us here? So I didn't see Alec jump up very quickly. I know he was politely waiting. So the chairman will now be in receipt of a motion from the distinguished gentleman from Alabama.
Thank you, Mr. Chairman. I move the committee grant H.R. 1119, the Satisfying Energy Needs and Saving the Environment Act, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule weighs all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Energy and Commerce, now printed in the bill, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule weighs all points of order against provisions of the bill as amended. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for the consideration of H.R. 1917, the Blocking Regulatory Interference from Closing Kilns Act of 2017, under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule weighs all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-62 shall be considered as adopted, and the bill as amended shall be considered as read. The rule weighs all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
Thank you very much. You've now heard the motion from the distinguished gentleman from Alabama. The distinguished gentleman offered the evidence of one rule, two bills, H.R. 1917 and H.R. 1119. Is there amendment or discussion to this rule? Seeing none, the vote will now be on the motion from the distinguished gentleman from Alabama. Those in favor signify by saying aye. Aye. Those opposed, no.
No,
Ayes have it, the ayes have it.
and we'd like a roll call.
Gentlewoman would seek roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall, Mr. Burgess. Mr. Burgess, aye. Mr. Collins, Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse, Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. Ms. Slaughter, no. Mr. McGovern. Mr. McGovern, no. Mr. Hastings. Mr. Hastings, no. Mr. Polis, Mr. Chairman.
Aye.
Mr. Chairman, aye.
The clerk will report.
5 yeas, 3 nays.
The motion is agreed to. Accordingly, the gentlewoman from the state of Wyoming, Mrs. Cheney, will be handling this for Republicans.
And Mr. Hastings,
Judge Hastings will be handling this for Democrats. I now will open us up to a question from the gentleman, distinguished gentleman from Florida. Okay. Thank you, and I appreciate the gentleman. I will respond back, allowing him that retort as the gentleman would choose. We do not have any other scheduled meetings for this week. Thank you very much. We've completed our work for the day. Thank you very much. She is